Hello, everyone, and welcome. I'm really excited to be having this conversation about the new federal privacy bill, the American Privacy Rights Act, or APRA. And I'm joined by Laura VanDruff of Kelley Drye, formerly of the FTC, and Jules Polonetsky of FPF, formerly of quite a lot of organizations. And I won't go through the whole long list because he's been at FPF for a very long time. But also, Congress has been at it for a very long time as well, trying to pass a comprehensive federal privacy law. There are more than 160 countries around the world with a comprehensive privacy law, including most of the large industrialized nations, except the United States. We don't have one. And there's been attempts to do this for about 25 years. Around the turn of the century, there was a push to do it. It wasn't a very popular push. Only a few companies supported it at the time, and it went nowhere. But there have been bills in Congress over the years, and they've gone nowhere. Sometimes multiple bills, and they've gone nowhere. But a couple of years ago, there was what seemed like a breakthrough. There was a bill called the ADPA, which I believe stands for the American Data Protection and Privacy Act. And this law went out of committee, which was further than many privacy laws. I think further than most of the comprehensive privacy laws had gone before. So there was hope for the law, but then it died. And this year, we have a surprise. A couple years later, there's a new surprise. Rather suddenly, a bill has emerged, this new ADPA law. And it's really getting a lot of buzz. People say that this could go all the way. I'm somewhat skeptical. I feel I did a post with the Charlie Brown and the football cartoon where Lucy puts the football down and he goes to kick every time, hopeful, and every time she pulls it away. And I wonder if this is one of those situations where, every time Congress does something, we jump at it. But that said, I want to explore, could this be the one? Because maybe sometimes someone does win the lottery after all. And but first, I just wanted to get your thoughts on the new law. Overall, what do you think about the law? Is this a strong law, a weak law? How would you assess or evaluate the law? What's notable about it? I'll start with you, Laura.
Well, first, Dan, thanks so much for having Jules and me. We're so pleased to be with you here to have this conversation. Although it does feel like it's Groundhog Day, whether it's Charlie Brown or these are conversations that are important and that we've been having for a number of years. You mentioned the Federal Trade Commission. I was there for about a decade, and during my service there, multiple chairmen called on Congress to enact comprehensive privacy legislation. It was important then, and in the years since, a number of states, and the count increases, it seems like weekly, although today apparently Maine is not added to that list, have enacted comprehensive state privacy laws. And that makes things complicated for business. It makes things complicated for consumers in terms of what the privacy landscape looks like. Jules's organization refers to it really as a patchwork, and that's exactly what it is. And so it's incumbent on Congress to address that if we're going to have something that looks like a comprehensive privacy regime in the United States. You mentioned that there isn't comprehensive privacy legislation, a law in the United States, and that's true with the exception of sectoral laws. We've got HIPAA, we've got Gramm-Leach-Bliley, we've got the FCRA, but otherwise there isn't comprehensive federal privacy laws. But in terms of this legislation, it does what the ADPPA didn't in terms of addressing private right of action and preemption, importantly. But whether that will overcome objections from important constituencies really remains to be seen. And some of the internal contradictions within the bill and concerns from important stakeholders in industry really also remains to be seen. Earlier today, there was an important hearing on the House side that addressed this bill, among others. And while I wasn't able to observe the hearing, I understand that there was broad consensus that the time is nigh. I think that that's been true for a long time. And so it'll be interesting to see what unfolds in the next handful of weeks.
Well said, Laura. And let me perhaps start with taking off maybe my think tank kind of neutral policy thinking hat and put on my hat as a former state legislator and a former congressional staffer and political junkie who's pretty active in electoral politics. And let's handicap some things that may help people watching think about the path forward. So the politics of privacy is really interesting. It's really complicated, and it doesn't fit into the same boxes that a lot of other issues fit into, right? Legislators typically vote in ways that reflect their constituents, their donors, the areas that reflect their party. Maybe they're part of the Congressional Black Caucus, and they're going to give some prioritization to poor communities and civil rights, right? Maybe they're an immigrant, and privacy isn't as easy to sort of put people into the boxes because voters don't go to the polls and vote for candidates based on privacy. I wish they did, as someone who's dedicated a career to the issue. But I've been involved in enough campaigns to say, hey, we ought to have a good view on regulating AI. Can we get the candidate to make a big speech about privacy? And the much smarter campaign consultants say, kid, come on. This is going to be, well, they don't say kid anymore, right? But they say, listen, this is going to be about immigration and student loan debt. And what are you doing to fight inflation? And are you looking to send money to the Ukraine? And do you support Israel? Or are you on the other side? Voters aren't pushing the buttons. And as a result, the political actors here, although they hear from industry and so forth, are actually typical consumers. And I think if you watched the hearing today and you saw how members of Congress were reacting, they were generally sharing the intense feelings they have as people who use the internet and use tools and maybe have kids who are on social media, and they all deeply feel that something needs to be done. Now let's sort of handicap what that means. It means that the personalities and the people involved on the committees are a bit more determinative of what you might typically think. So, for example, you might typically say, well, Democrats, they want regulation and they're happy to support, litigation and private rights of action. But today you heard the Heritage Foundation, sort of historic bastion of, conservative thought, maybe supporting free enterprise, say, we need a private right of action. Wow, right? The world is not the way it typically fits. The chair of the Energy Commerce Committee, Cathy McMorris Rodgers, is retiring. And although Congress spends a lot of its time sniping at each other and fighting partisan battles and, bopping each other on the head and stuff like that, they do care about respecting sort of the tenure of their senior members and, will go a little bit out of their way to recognize that a priority, landmark effort of a senior member who's leaving, who's worked for a long time on an issue, deserves priority. And indeed, Cathy McMorris Rodgers has worked on this issue for a while. And remember, this committee reported out the earlier version of this bill, and you certainly heard a huge amount of consensus today. Also, the House is a little bit more of a dictatorship than the Senate. Now, that might be seen a little absurd now, given that the Republican margin is so narrow and the speaker, is constantly losing, speakership based on that narrow margin. But generally, the House is set up to avoid being a giant mosh pit where every member can block everything. And so the committee chairs play a significant role. The speaker plays a significant role. And although we haven't heard yet whether the speaker thinks there's time on the floor, and there are only a very limited number of days that both houses are going to be in session during the rest of this year. So, but on the other hand, again, they may want to do something to respect, their retiring member, especially if there's a broad consensus. It passed the committee, quite strong. I don't remember the vote, but if there were one or two, it was near unanimous. And you didn't have Frank Pallone, the minority, the Democratic leader, on board, but he was saying very positive things, and he clearly seems to be positioning to make sure that the kids-related components. Remember, today's hearing was not just on the APRA, but it was also on the COSA and the COPPA 2.0, and ensuring that there is a kids component either added to this bill or as a companion package. So very strong likelihood that we're going to see it passing in the House, with the caveat that there is a narrow window and not a lot is getting done that doesn't absolutely have to be getting done, right? FISA renewal, budget, massive, priorities are kind of the only things that are happening. But on the Senate, every member is, a presidential candidate. Every member has national media attention. Every member has the ability to gum things up. And Senator Cruz, who was not part of sort of a club working on the legislative efforts last time, is newer. Not that he's been new to the committee or the issue. He's, helped lead some of these hearings in the past. And his critique, I think, is a bit more challenging. He's not as fond as the private right of action. He's been a critic of the FTC and is worried about the extensive rulemaking. And of biggest concern, and this could be the dangerous poison pill, the good thing about the APRA is it's got strong civil rights protections. And we testified in favor of the ADPPA primarily because A, we wanted to support the process moving along, and B, we said there are great civil rights protections in there, ensuring that digital civil rights, don't get lost just because there's an algorithm. And some people said to us, shh, don't make a big deal out of that, because not everybody will be so enthused about that. It could become a flashpoint issue in sort of the culture wars. And well, we spoke up, but it didn't become an issue. Senator Cruz right away has focused on flagging, DEI and wokeness and all these issues that Congress, is battling about, and that there are deep divisions. And indeed, obviously, there are strong values that support civil rights, that are data-driven, that are in this law. Now, I would hope, and I'll conclude with this, that it doesn't need to be a cultural issue to recognize that civil rights that we have reflected today in law and generally support widely across the country don't go away just because digital is involved and just because algorithms are involved. So I'm hoping, but I worry a little bit that we could fall into that sort of national political debate, and then that obviously wouldn't be a positive for moving forward.
I'm curious, and you raised the issue of likelihood of passage and a number of things, but I think the big sticking point, the biggest one recently, has been preemption. For a long time, it was the private right of action, which was very controversial. And now in the last two bills, it's there all of a sudden. Many things that used to be controversial, like a right to delete and other things, are now seemingly standard in these laws. So things are changing and evolving, but preemption is a big sticking point because of the state laws that are out there. Although this law is stronger than a lot of the state laws, still the idea of preemption is shuts down that engine of law creation. And just today we saw a letter from the California Privacy Protection Agency, the CPPA, coming out against the law, having some criticisms of it. And in particular, very upset about the preemption part of the law, which would essentially, get rid of them. And I wonder, I've long thought preemption is a really big hurdle, almost impossible hurdle, especially in the House, because so many representatives are from California. Why would California essentially vote to eliminate its own power? Just because it wants to help out the rest of the country? Would say, well, then pass your own laws. But California, has exercised for decades now a very big influence on privacy. It's got an economy larger than most states combined. And so when it says, this is what you must do, and it makes the rules, everyone follows the rules. So from California's point of view, why would you vote for this? And then could you do this without California? And then there's other states that I think are Washington and Illinois. I don't know if this law will preempt the Illinois law, BIPA, the Biometric Information Privacy Act. But I'm just wondering, other states might join, so that it might be really tough. And I'm just wondering, is there a way forward?
We should give California credit for setting the stage for a strong national law, which we would not have had if the California voters, not the legislature, because the legislature didn't pass the current law, the ballot initiative that Mr. McTaggart passed. I've heard him say that he's not opposed to a national law as long as it's as strong as California. I don't want to mistake that. Somebody can correct me if I'm wrong. But the basic rights that almost every state has now put in place, and the basic rights that are in this bill are really built on California. California should applaud and take credit for being the basis of what has become a national law, and frankly stronger because it's got a private right. It covers a whole bunch of areas that the California privacy law doesn't cover. And we note that it does not eliminate, it shuts down the FTC rulemaking. It does not eliminate the CPPA. It empowers it with the ability to enforce this very detailed law. They'd have tools and statutes and details that they don't currently have. So look, the politics may be that, the members who did oppose, previously preemption may sort of still stick up for California. I'll just note that this isn't their law. They didn't pass this law. This was, a ballot initiative. And I think we should applaud them for putting in place this national law. Pelosi is no longer the speaker, so she had a kind of a one-woman powerful finger, whether or not a lot of members supported or not. The speaker wasn't going to give it floor time. That's no longer the case. So look, a lot of members were on record against it, and obviously Mr. Soltani and others may disagree, but they will be one of the most powerful enforcement agencies with staff and expertise being able to utilize this law. I'd also say, if I saw any states that did like incredibly creative, unusual things, I'd say, wow. But right now we're doing like versions of the same thing with just enough difference to like make the privacy compliance people rip their hair out because it's not exactly the same. We've had a little variation now with Maryland and some other laws that are actually building in strong data minimization. But guess what? This federal law picks up some of those themes and has a very strong, data minimization. It's a very strong law. And that's frankly, we all recognize the political trade-off for preemption, that it wouldn't be, and that's what's prevented data breach law, right? Data breach law, critics have wanted the strongest version, and industry sort of wanted, something else. And so we have 50 data breach laws and we can't do one. This jumps right in. It's tough. It will take a lot of compromise on industry side and civil society side. This is a really tough law. It breaks some stuff, which, some stuff we may not want to break. And we probably need to think about some of the rules about how it treats research and, how it completely clobbers ed tech, perhaps beyond, what might be expected. But it's a pretty tough law, and that's the trade-off.
And Dan, you asked about California specifically, but Jules raises the question of states that do things a little bit differently. I think it's worth mentioning here that Washington last year, of course, passed the My Health, My Data bill, the law that went into effect just last month, and that is preserved, right, in this bill, would be preserved in the bill. And so, with respect to preemption, it does carve out this, to use Jules's turn of phrase, this creative approach to protecting health information. So it's not just leaving HIPAA alone. It's leaving Washington's approach to health information in the wake of the Dobbs decision alone, for better or for worse, because there are certainly some very valid criticisms of the Washington approach to health information. But with respect to that, and whether that's because of Senator Cantwell or for other reasons, that is also left alone.
So do you think it's going to, how would you rate whether it's just in terms of not normative, but just descriptively, what would be the odds if you're betting money on a likelihood of passage?
I told all the international data protection authorities who were in town last week for IAPP, had a chance to address them. I told them, there's no chance privacy law is moving. There's no agreement between the Senate and the House. Cantwell hasn't been able to agree with the Republicans. Nothing's going to happen. And wow, all of a sudden they have a deal. So I'm going to take my money off the table. I still think that folks should focus on the state laws today that are starting to kick in. They really, Maryland and others really up the game in terms of sensitive data, in terms of bans, in terms of minimization. And a lot of those issues are reflected in this federal bill. So whether it happens sooner or later, anyone reasonable who's sort of thinking, hey, what's the future of ad tech? Can I continue all the things that I'm doing with data without worrying about sensitive sites? No, you can't, whether it's the state laws or the eventual federal law, whether it's data minimization. Guess what? That's actually a serious importation now, into our reality. So I think the path is clear, and the path is that we're going to have more detailed privacy policies, more detailed transparency, more effective, opt-outs and deletion rights. The path is clear.
So I agree with where Jules is, both normatively and descriptively, and in terms of counseling clients, it's important that clients keep their eye on the states, because states are certainly taking action. We've got a number of state laws on the books, and we've got states taking action every day, including Maine today, although the legislature didn't approve that bill. And so, I mean, that's where the action is. Should the Congress have take action with respect to comprehensive privacy legislation that preempts these state laws? It should, because industry it deserves to operate under one set of rules. But that's been true for a generation, and that hasn't been sufficient to motivate a number of Congresses under many different leadership regimes to act. Now, the question is whether the current set of political considerations, which Jules just summarized beautifully, whether those considerations are adequate today to get us there under an unbelievably tight time frame. I don't know. I'm skeptical by nature, so we'll see.
And then to the California defenders, one giant hole in California and most of the other state laws, for instance, is not-for-profits. There are not-for-profits that are the biggest marketing hounds, in the country, and who are data brokers, pure and simple, but who are, exempted from most state laws. This is a huge expansion. The FTC doesn't typically have an ability to act against these not-for-profits. AGs, sometimes do. Sometimes FTC's got an angle, sometimes it doesn't. This is going to be for the first time, right? I think Colorado captures some not-for-profits, Virginia, but California does not, nor do most states. And that's a huge loophole that in some part, not all, right? You still have to qualify, and but it's going to capture a lot of the biggest, most commercially oriented not-for-profits.
So on the preemption, I just want to say something quickly, and then jump to some other issues about the bill. I mean, I've long thought, preemption doesn't have to be in the law. It seems like the current flavor and the current, truth from on high is that you have to have preemption. And I think that's what industry really wants. But, 5-10 years ago, it's like you cannot have a private right of action. It's just no way. It's going to kill the law. Or there's certain things that are just absolute no-nos. And then, everyone's just kind of got over the tantrum. And I think when we look at previous privacy laws like HIPAA and others, they don't preempt. If the law is strong, if it's a good law, states are not going to have an incentive to pass laws. They're going to just enforce this law. But if the law is weak, then you have the problem. But HIPAA is a strong law, and we don't see big headaches or big problems from HIPAA not preempting. No one's freaking out over that fact. So I do wonder, it used to be this big freak out, like, oh my goodness, oh, look at all the data breach notification laws. It's impossible to comply. We're never going to be able to do it. We need a federal law. And I thought, oh, of course, it's Chicken Little screaming, the sky is falling. And then look, they gave up. They just like, okay, now we don't really seem to care anymore. So that effort just kind of fizzled out. But I'm not saying compliance isn't hard and it's not going to be very difficult. But I just wonder, if you could get over this. And the thing about this is that, yes, it's true that the legislature in California didn't pass the California law. The voters did. So in essence, what the representatives would be doing would be essentially, telling the voters, sorry, but we're going to take away your power. You're one instance where you can actually directly, vote on something, directly influence policy, make a law where, without this initiative, it's not clear any of these laws would have happened. The people said, we're not happy with privacy law, and they said something. And basically, this law would essentially snuff out that capacity. So I applaud the federal law. I think it's great, but I do wonder, if preemption has to be the price. I think industry seems fixated on it, but I actually think it could work without preemption if the law is good, and it will stop the states from passing the laws. But the other thing about this law, one thing the law does, and I wonder what your thoughts are on this law, is it gives the FTC a lot of power, but there's some implications about this too. It says, oh, we're going to create this new division of the FTC, right. But it's not clear why the existing divisions can't do it. But I do also wonder what would happen to Section 5, because we have Section 5 of the FTC Act, and that has a very broad scope, and it would allow for a lot of the things that the law does, like data minimization, the FTC could conceivably do. And it could conceivably, it's already working on a rulemaking. So the FTC could do a lot of these things. And so the law now will give the FTC that power. So then let's say the FTC says, hey, we're going to do things beyond the law with Section 5. Would that start to get, would the FTC be essentially too chicken to do that? Because that would seem like really weird, right? Here we just passed this law and the FTC's off doing other things with Section 5 now. So that might substitute or trade Section 5 for, this new law, which, maybe the law helps a little bit, but it also could, limit the things that the FTC might be able to do in Section 5 as it's been evolving Section 5 jurisprudence in some really interesting, neat ways. And then the other devil's in the details is, how much more money will the FTC get? So now you take, you put all this to the FTC, but if you don't, double, quadruple, quintuple the FTC's funding, then it kind of becomes an unfunded mandate where, the FTC now, instead of doing this bunch of Section 5 cases, now does the same bunch under this law. And we really don't get that much more, or do we? And I'm curious what your thoughts are.
Yeah, first, I think it's a really interesting question, right? Because the bill would call on the FTC to create an entire new bureau. So really, the FTC has acted as the United States functional privacy DPA again for more than a generation. And Dan, you raise how it's used Section 5, because Section 5 has which prohibits unfair and deceptive practices. That is the only tool that the FTC has, with the exception of the sectoral laws that I mentioned, in order to protect U.S. consumers under federal law from against privacy violations. So here in the bill, it would give the FTC some limited APA rulemaking authority. The FTC has, in prior testimony, called on Congress to provide broad rulemaking authority, but here it would be more targeted on what constitutes sensitive data, effectuating consumer rights requests, on opt-out mechanisms, data security, where FTC has been active for a very long time, and then on large data holder impact assessments. So these very specific areas where FTC would have this rulemaking authority, but then also have enforcement enforcement responsibilities, along with the CPPA, state attorneys generals, et cetera, which Jules mentioned also. So these a number of enforcers. But as you mentioned, that if Congress is not appropriating adequate funds to support the expanded mission of the Federal Trade Commission, it would be really difficult for the United States to stand on equal footing with, for example, our European counterparts in terms of really having both the regulatory might of our counterparts, as well as the enforcement arm. So the FTC has for a long time been small but mighty, but this would again just really expand that mission, and it would be necessary to have a commitment from Congress to support that for a long time. In recent years, we've seen principally from the House, but really some criticism from Congress about what the programmatic goals of, in particular, this FTC, but prior FTCs also have been pursuing in terms of their objectives. And to the extent that politicization continues, you can imagine that the budget of the FTC will continue to be under scrutiny, and that sort of the politics of supporting the agency charged with the privacy of Americans could be really problematic. So unlike the CPPA, which has a dedicated funding source, it could really just be another football, to extend your metaphor, of Charlie Brown.
Dan, I'll say, look, obviously money for the FTC is important, but if the goal is the best possible compliance and the best possible enforcement, the area where the U.S. sometimes has a global advantage is when we actually legislate in clear ways, where it's clear what's in, what's out, what's legal, what's not legal. And maybe I'm shaped a bit by the fact that I was a chief privacy officer and work with lots of chief privacy officers. Most of their day is, give me a clear rule and I'll throw my body in front of it. I'll make the case. I'll argue. I'll prevent. And I think most reasonable organizations get that when you can have clear advice that says this can't be done, most reasonable don't do it. And laws that are clear are also easier to enforce and easier for the FTC and AGs and others to collaborate. When every state has a different version of what deletion is and what access is and what sensitive is, a lot harder to have really sort of collaborative cross country work where the many enforcers can leverage each other's work in an effective way. Now, I think this law's got a lot of fuzziness in it. The GDPR's challenge is that we're going to have 10 more years of court decisions to learn what we thought GDPR meant, right? EDPB just told us their view is, no, you can't, be paid for your data if you're dealing with a big platform. I don't know, half the legal experts thought that was fine. The other half thought it's not fine. There are business models throughout Germany and Austria that are specifically designed around that. Maybe they still can because they're not a big online platform, but maybe they're the main media organization where you really don't have that much choice. You can't get the news from the major, newspaper. The challenge with GDPR, which is obviously, respected as a strong law, is that it left with lots of uncertainty and lots of clarity, which is, the result leading to sort of these giant enforcement fines. We need this law to be clear. And in the range of areas where there is confusion. Right now, for instance, I thought I knew what it meant to regulate research, right? Research has got to go through an IRB if it fits into certain categories. Here under this law, I'm only allowed to conduct research if the data is de-identified. And I can only do product development if the data is de-identified. And that's written by somebody who's never sat at the table and understood. Now, if you have a wimpy standard for de-identification and you can just maybe, pseudonymize data in some basic way, fine. But if the goal is to actually learn, who is affected poorly by a product or by a various experiment, if we want to understand who's being affected, or harmed by social media, and we want to understand, is it males versus females? Right away, boom, you've just cut your class in half. If I want to know whether it's young women versus young men, I've just sliced it, right? All of these things that make data, more likely to be identified carve you out of being able to do effective product development or effective research. So there's a lot of work, frankly, that needs to be done to sort of nuance the tool. And I know there are civil society folks who think that there are holes that they want to cover as well. So there's a ton of work, but the best thing we could do, certainly let's fund the FTC adequately, but a clear law where we understand what's in or out gives the FTC an incredibly powerful tool, as well as AGs, as well as the state agencies.
So I guess one of the challenges I found is the more I look at privacy, the more I realize like clear rules are nice in theory, but very difficult to achieve in fact, because privacy is complicated. And data minimization is one of the toughest things to actually figure out. How do you be clear about it? It's a very context specific type of inquiry about, what is your purpose? And, ultimately, then what data is necessary for the purpose, which it's kind of like it depends, or I know it when I see it. And I just wonder, can we really achieve clear rules? And will clear rules lead us potentially astray? Like we could have bad clear rules, or, more, fuzzy rules that can evolve, that could get better. And I also worry too about these safe harbors, which are often, companies like make it clear, make it really easy, make it easy so that we can just turn it into a checkbox exercise and we can just do it and feel comfortable about it. And I think that maybe, a lot of these things require judgment calls. They require thought. And, you can't just automate your way to privacy and feel totally safe and just check a box. That's why you have privacy officers that hopefully are thoughtful and really, take the time to mull things over. But that's my concern, is that if we push for clear rules, or and particularly the safe harbors could be this dumping ground where, you have perfunctory compliance activity that's not very meaningful, and then they get a pass.
Well, the FTC has the authority here to approve these safe harbors. They truly have to be independent. We've not succeeded previously, frankly, in having, very substantial number of safe harbors. We've got the limited number of couple ones, but frankly, there's been no giant incentive. So today, if we have something like data minimization, and we don't know what that exactly means for different sectors, and it might be very different for healthcare, where maybe I want, more data for a longer period of time to detect, anomalies, and maybe for advertising, it's going to be different. So I think there's going to be immense incentive to structure, and the FTC's got to be a good partner here, but to structure serious certifying entities that on some of these key issues where, we need nuance, and where it might even be different for different kinds of companies and different sectors. There's no way to legislate, as you pointed, every single, iota and T. But one clear thing from the hearing today and from this bill is that Congress and the FTC don't trust industry to just figure it out and then don't worry, trust us, we'll decide what's reasonable, or we'll do a risk assessment, right? They're specifying, one of the commentators said, hey, is there a legal basis? Yes, if it's not one of the very specified type of things that are called out, you don't get to do it, right, without consent. So that's a very narrow list of items. I'd like to see the certifying groups, for instance, perhaps for certain sectors, be able to add or approve, or the FTC rulemaking, I think already is allowed, approve other additional areas, so that we can, have some of that flexibility and bridge the gap. We've never achieved it. I do think it's possible if it's set up in an honest, trusted way. Frankly, if we did this previously, we wouldn't be in the hole we were on, right? If the problems were solved by strong industry groups who kicked out the bad actors, we'd be in a very different position today, where because of, case after case of data going to the wrong place, data going abroad, data going to the wrong actors, nobody trusts that industry truly can do innovative things with data in a way that is trusted and safe.
So I'm not disputing any of that, Jules. And Dan, I take your point about the box checking exercise, but I think that, there's a risk here also, though, that the bill overcorrects with a private right of action about data minimization, because the plaintiff's bar certainly has endless creativity when it comes to, what where it will go with that. So, Jules, you just identified some clear violations where exercising that private right of action may be warranted. But my concern with how the bill is drafted is that there could be, real exploitation of that to incentivize or I should say disincentivize what are perfectly benign uses of data that benefit consumers, competition, industry, and that maybe we're overcorrecting because of the concerns that you identified from today's hearing and others.
I think the important point of a private right that the civil rights groups have really expressed, right, is that historically they couldn't rely that historic rights to protect race and religion and so forth would always be led by local authorities, and that you needed, when there was discrimination and real harm, the ability to have your day in court. And they've made that quite clear, and I think that that's been embraced by many in Congress. I think, how do we do that? How do we ensure that if somebody is, some algorithm is, just not allowing one class of people, and somehow the regulator in that town is more than happy that, nobody who comes from a particular background can get a job because, they're bigoted themselves, that there's a way to go to court and do something about it. I think we have to avoid the bonanza of, garbage suits that have just been a giant, funding bonanza, and just led to, settlements one by one with nobody really thinking that they can comply. We need to avoid that. And I hope that there's a way to sort of ensure that the law recognizes that if someone is really harmed, then they're discriminated against. We kind of want them being able to have their day in court without unleashing, garbage litigation that just ends up being a cost of doing business and kind of enriches the wealthiest trialers.
That's exactly right. Yeah.
So there are some that have argued that, in some ways the data minimization provisions and the law is stricter than the GDPR in certain ways. And I'm wondering, and there are others that say no, far weaker. And I'm wondering what your take is on, because it seems to be one thing that's really interesting about the law is how varied the opinions are on how strong the law is. And actually, I find myself really struggling because I see some things that look strong, and then I see like big catches or loopholes or other areas, and it's hard to ultimately come to a conclusion here. And I'm just curious what you think.
Jules.
Well, I think the most powerful thing, which is perhaps too restrictive, is the fact that it really is no legitimate, interest basis. At the end of the day, there's a range of activities that under GDPR, if you do the appropriate assessment and you identify the harm and you show how you minimize it, and presumably there's some legitimate reason and lawful basis to do it, you can go forward with exceptions of areas where you need consent or a different legal basis. This law says, no, here are the things that you can do. And then sort of that's the end of it. And I think, frankly, that's probably a little too restrictive. They thought about a lot of things, but there's going to be use case after use case that I think we'll bump into where you say, well, that really ought to, be doable today, but it wasn't listed out in the law. So I do think there's some, and I get why, right? I get that Congress and skeptics don't want to trust that sort of balancing assessment process. But guess what? That's how we're going to be regulating AI. At the end of the day, there are micro decisions, and there are innovative new products, and there are new ideas, and there are areas where we need to empower people. And it starts doing that by saying you've got to have a privacy officer, the security officer, the CEOs in some cases need to certify. So you need some place where an assessment can be done that says, this is not exactly one of the specified purposes, but this provides benefit to users. If there's any harm, I've mitigated it, I've minimized it, right? I mean, that's what today's FTC jurisprudence does. That's what product safety does. So that's why, frankly, it is today more restrictive. But I do think that that's where we should learn a little bit from Europe, which, even though it's got, its 6 legal bases, has some flexibility for new uses of data, even if they're constrained and even if there's a sort of a process you've got to go through.
Yeah, I agree with all that. And I think, that as we look ahead to where we may see some adjustments, I'm optimistic that the listening sessions that the committee staff are doing, that this is going to be one area where they're receptive to some feedback, because this is, while there are, I think that there's going to be some skepticism about feedback from industry. I think Jules is exactly right, that there are benefits to the kinds of risk benefit weighing that privacy professionals do every day in the interest of just making things work, as opposed to just making money for shareholders. And so that's really necessary, and otherwise things break.
So one thing that the law does, and I'm wondering your thoughts, because this is sort of typical of the state laws, is to kind of exempt small businesses. And a small business under this law is $40 million, which, I think some of the worst offenders are, these startup tech companies that basically it's like move fast, break stuff. They're just worried about their survival. They start caring about privacy when they get big, but when they're small, there's a lot of times where they could, and it's like 200,000 individuals. Well, that's more people than most cities and towns in America. So I wonder if this is too big of a gap, like it's regulating only the really big companies, and that's a problem, or is that okay? And should GDPR doesn't make an allowance for small business. It focuses on if you have the data and you're doing these activities, you're affecting people, you're covered.
Well, it's not just $40 million, right? It's also transferring data of 200,000 people. So, I mean, you hit that cap very quickly if you're in the data business. So $40 million might take you a while to get there if you're a startup, but I mean, 200,000 people, it doesn't if you're in the data business. So, I mean, I think that's the balance that the drafters achieved here.
And Laura, just wearing your FTC hat, I don't know that the FTC jurisdiction went away for all of those businesses to whack them on the head for doing things that are deceptive or unfair, which exists today. They have less of the specificity, and frankly, the FTC may use some of this to interpret, what is reasonable or what is deceptive or so forth. So most of those businesses, if they're looking for guidance, have something to look to instead of sort of a murkier history of FTC settlements and that sort of thing. Like that's fine
Right.
for lawyers and big businesses. Startups can't determine exactly how they should advertise by analyzing 100 FTC settlements, and so they kind of just frankly go without. So there's probably some way that we need to make sure that smaller businesses can't do significantly harmful things, even if it's at smaller scale. I mean, you could be a tiny business that really does abusive stuff. I'd like to hope that those things are probably captured today by the FTC's broader activity, and will continue to be captured by the FTC and the AG's broader enforcement tooals.
And this was exactly Dan's point earlier, is that, the question of does this supersede what the FTC is doing? And the answer is, I hope not, because the FTC's program, not just in the privacy program, but across the spectrum, is important. And your mention of the AGs, Jules, is important also, because the AGs are on the ground and seeing what very small businesses are doing in communities across the United States.
The people who will not be regulated by this law, or most of the state laws, who are now filling up your mobile phone with text messages, which nobody was going to spam you with text, right? That was intrusive. Well, who spams you with text messages right now? And who spams you with email messages? And who does the most micro targeting that makes Cambridge Analytica look like a toy, pencil? Our elected officials, who should model themselves, even if they're not covered constitutionally. It's challenging to tell them, how they campaign and what they can say and do. But I would urge our members who were so passionate today, and in the Senate and the House, to look at their own campaign websites, which are full of all of what they are now condemning as terrible, illegal, and horrific, and to model at least good behavior as they do something that is highly important. They're not trying to take our money. They're trying to take our souls, our votes, how we think about each other, how we think about immigrants, and frankly, not only from big central campaign databases, they're pushing it out to volunteers like me, saying, here's what all your neighbors did, and here's what all your neighbors might want to do, and here's who you should target based on this reason, and so on and so forth. So a message to our policymakers, walk the walk, please. Talk the talk, but walk the walk.
Well, I've long thought campaigns are they're the worst privacy abusers, and I don't think they should be exempt. I think that this law should regulate across the board, and I think I think that expand the FTC to be able to cover everybody and everything. There's a kind of personal and familial use that the GDPR exempts, which I think makes sense to exempt. But beyond that, I think everyone should play under the same rules, including most government agencies too.
Could they, and constitutionally, like, can we tell politicians like who they can email or who they can direct mail? I've always thought that there's some real
speech or debate problem.
Yes, no, you can give people the right to opt out and enforce opt out rights, because that you can't like tell them like you can't send something, but you can enforce an opt out, like, because that basically there are cases that say the First Amendment can stop junk mail, and I don't think there's any reason why that wouldn't apply to political messages as well as commercial, because it's basically empowering the individual. The court's rationale is the individual. Free speech doesn't mean that you have the right to pester or harass someone or send junk to their house if they don't want it. But the government can't tell you that you can't send junk to their house. But if someone says, I want the government's help to enforce my decision not to get it, I think that is.
But how much further could you go? When I first ran for office, I ran against the machine. I was an upstart, and I didn't have enough money to mail every voter in the district or every resident in the district. And I emailed the elderly Jewish senior citizens of Brighton Beach, Coney Island, Bay Ridge, my part of Brooklyn, because I knew they were going to go for me. And I emailed them 3 times, and I won in a landslide. Should the law say, as it would perhaps in Europe or Canada, that targeting voters based on ethnicity or political party or other data like that, which is what this is which is to some degree what it's doing for the commercial brokers, could it tell me not to reach the people who I think are the most likely voters? I mean, that's what they want to hear.
I mean, because I do think things have gotten way out of hand with this, and I'm not sure how good it is for society. Is Cambridge Analytica good for society? Is all this really good? I see your point, but I also think there are some real big problems when if we have no rules and we just exempt political campaigns from doing massive data collection and data analytics. I think
I'm campaigning for reproductive freedom in a couple of swing states where I know there's a whole evangelical group that's against me and a whole group that's for me, and I want to go for that sort of swing voter that might be moved by this very sensitive issue. Where do you feel about women's reproductive rights, or I might want to target that audience. So like I see the bad, I see the good, but I also think there's some real constitutional challenges to telling people they can't do that. Maybe it's more divisive than it's worth, but.
Well, there's also differences between speaking and collecting data. Because you can't stop someone from putting out a message, but you can stop people from collecting data, because collecting data is not speech. Collecting data is collecting data, and so I think that there's some First Amendment doesn't protect everything; it protects speech. So and a lot of this is gathering data and massive data analytics, but we're getting beyond what the law actually does, which is focusing on the commercial sector. And then there's a lot of instances where you have
and the not-for-profits.
Yeah,
no, I think that's going to be a big surprise to a lot of big not-for-profits who have not dealt with this. That is, we have a huge not-for-profit sector. These aren't all charities. These are big organizations that have lots of health data or lots of sensitive data, or big national groups. ACLU might be covered under this. Frankly, they do a lot of national data collection and campaigning around the country. And
yeah, I mean the law does do a lot of things that some looks says it's stricter, but there are other things that the GDPR does that the law doesn't do. There are other approaches that I'm been skeptical of, like sensitive data, which I applaud the desire to do something for that. I just don't think it works. And then there's also some categories left out of sensitive data that are somewhat problematic too, about what data is deemed sensitive and then what data is not deemed worthy. And so that we have a lot of challenges there as well.
Note that the bill protects sexual behavior, but not sexual orientation, which again may have been a bit of a compromise, but falls short of protections that are expected and protected under laws generally. If I'm a member of a gay and lesbian group, well, that can be used. Only actual behavior is sort of protected. So I'm hoping that that's something that can be fixed to broader protect the LGBTQ audience.
And also exempting the Gramm-Leach-Bliley Act. I mean, that is one of the weakest privacy laws out there. So exempting that seems to be a big loophole. Like, I just love to be regulated by the Gramm-Leach-Bliley Act and get out of all this. I think then is a big boon to the financial industry to not be covered. I think HIPAA is close enough that it's fair to say if you're under HIPAA, you're not under this. But I'm not sure it's equivalent with the GLBA.
Those agencies decided that the FTC is the Uber regulator of healthcare, of every sector expertise. Right now, these companies are coming and saying, I need this data. It's not HIPAA covered, but it's really important to me. But now the FTC has got to determine that. Why should...
I was just going to... Yeah. So, I mean, Dan, your point on health information, or I should say on HIPAA, while HIPAA certainly has de-identification standards and privacy rule and a security rule, I think that, in the wake of Dobbs, there's certainly been a recognition in Washington and in other states that there is a delta, and that some of that, Jules, to your point, is being filled by the FTC. There was a blog post not immediately, but then a couple of months after the Dobbs opinion about what the FTC would do, consistently with the Biden administration's announcement about that, to protect that information, and they've executed on that, but I don't know that HIPAA is enough to protect health information. Your point on GLB is interesting. I think that it's consistent actually with what Jules, with what you're talking about with respect to nonprofit information. It's just sort of been set aside under all the state privacy laws.
Yeah, I mean, the state privacy laws do set aside that. And now we're seeing the specific health privacy laws. I mean, I think it's very hard after Dobbs to really provide the kind of protection to health data. I think also one trick and difficulty we're going to see with this law is when it exempts health, what exactly is health from the preemption? So it's going to be a lot of ambiguity, I think, on what can the states regulate and what they can't afterwards, because right. I think it's really unclear. What is health exactly? It's more than HIPAA, because HIPAA only covers certain types of health information. Conceivably, all sorts of types of data can be health data, which if you look at the Washington Act, location data is health data, and exactly. All sorts of other data that people wouldn't think of as health data can be used to give rise to inferences about health data. So it's really hard to make these carve outs and to say, oh yeah, we're going to neatly allow health regulation and preempt this, but not preempt that. I wonder how that's going to work in practice, because I think it's going to be a lot messier and a lot more complicated in this world of big data, where these neat little categories of health data and this type of data and that type of data, I'm not so sure that we can carve the world that neatly in today's age. And so then it becomes, well, what laws are preempted, what aren't preempted? It's going to be a lot of uncertainty for decades, perhaps, on this issue.
Can and should the FTC be the arbiter of every possible area? I mean, it's one thing where they can say, hey, advertising, you don't really need it for that stuff. That's just too intrusive. But can the FTC say, health companies, when you have data that is outside HIPAA, here's really how you ought to be using it? And banking and finance, which is complicated and has its own issues of why they might need data for fraud or this or that. Like, it feels like we've just decided that every other expert regulator, automotive, right? What is really needed for automotive, again, for product development? Is the FTC got a big automotive team? Do they have a big, deep health team? I think there's a need globally to recognize that privacy is not the law of everything, and it shouldn't be, and that there are balances with other issues, not just this general innovation problem, right? But here's what we need for building cars that are safe And here's the regulator who actually understands when you're full of baloney and you really just need it for data brokering or advertising, and when you really need it for serious product improvement, which means a safer, maybe more fuel efficient car. Should that be the FTC? New banking products, again, that are outside the traditional scope. So whether it works with those regulators or whether those regulators are perhaps the ones who ought to move forward. Look, it didn't work well for DOT. Like for a generation, where's been DOT dealing with privacy? Now I get they're worrying about planes falling out of the sky and like my luggage. And so privacy was probably last on their list, but I was heartened to see that DOT woke up recently and, is focusing a little bit on this. But they might know better about exactly why airlines need to move my data around in all the complicated ways that, intersect with the mess that is our transportation system.
Maybe the answer, I think that's tricky because in one sense we do, a lot of industries are mixed and they do different things. Companies are doing multiple things and not just in one sector. They're kind of across different verticals. And then it becomes tricky if we're going to have, radically different rules for all these different verticals that kind of mix and match. I think maybe the best approach is to say, look, the FTC creates the baseline rules. And then agencies in a sector could make differences or deviances if they could justify in a rulemaking why there should be a different set of considerations or why the rule should be adjusted. Then they could kind of make derogations from the FTC rule, but at least you'd have a kind of baseline, and then it would make the other agencies have to explain why that doesn't quite work, rather than everybody reinvent the wheel and try to come up with rules for data use that could be very, very different, not because of any particular need for the sector, just because, some have thought about it more and others haven't.
In fact, I guess if HIPAA was expanded, it works like that, I think, under the current law. We're just assuming none of those agencies are ever going to improve their laws. But technically, the carve-out doesn't freeze the law as of today. If HIPAA covered something more, right, with more detail or less detail, it would carve it out of this law going forward.
Okay. So I guess we will see what happens. So no one wants to give me a percentage or odds. No one wants to put money down to make a bet on this law. Last chance. You can call it, say it's going to be the time.
I think, but will we take a kick at the football is the question, Jules. Are you willing to take a swing?
I'll say this passes next year because it took GDPR 7 years. And again, GDPR is mostly what was in the directive and law for a generation in most European countries. So let's go slow. We're regulating the entire economy, trillions of dollars. We're regulating AI in this law. We're regulating the future. It's not terrible to bang on it and nuance it. The law needs a lot of work, but this is the framework that Congress has accepted. Last time around, now it's time 2, maybe 3 will be a charm. So I say yes, next year.
Okay. I made a bet, I think it was back in 2018 or 2017 with Cam Kerry. He was sure that we were going to have a federal privacy law within a year. And I wish I put money on it. And I wish I did it where each year the bet would continue to be renewed because I'd be rich. I could retire.
I'm a skeptic, so I'm with you, Dan. But I really appreciate Jules' optimism. So I will celebrate with him next year if it becomes true.
We're halfway through the process.
So thank you both for joining me. This has been a really fun conversation, and we'll wait and see what happens. So good afternoon, everyone.
Thank you.